Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about competing statutes. Cases that should have gone to the Supreme Court of Canada, but didn't. Okay, so I know this sounds really boring, but the case of Alex Gilmore actually raises some very interesting issues. As our law expands to include more and more administrative tribunals dealing with things that the courts would ordinarily sort out, we run into situations where the administrative work done by one tribunal conflicts with the administrative work done by another tribunal, and both tribunals can't preside over the same thing at the same time. And so there are conflicts that occur between tribunals. This is what happened to Alex Gilmore. Alex Gilmore had a property dispute. The facts are not really important. What happened was he sought relief from two separate tribunals. And unfortunately, the law for one tribunal clashed with the law for another tribunal. And Mr. Gilmore asked the Supreme Court of Canada to answer some very interesting and very important questions, including what happens when there's these conflicts between tribunals? Who rules over everything? Also, Mr. Gilmore wanted to know from the Supreme Court of Canada what happens when a tribunal decides something that's not within its statutory jurisdiction but is related to the material that they're supposed to decide and relates to the material from another tribunal. These are very interesting questions because we've seen a shift away from dealing with disputes in courts to dealing with them in the administrative law system. In British Columbia, for example, we've moved investigation of impaired driving cases largely out of the courts and into an administrative driving tribunal. Similarly, we've moved civil disputes, small claims actions, to the Civil Resolution Tribunal. Where these things conflict, and obviously those two wouldn't in BC, but where these things conflict is going to raise really new and undecided areas of law. The Supreme Court of Canada in this case had the chance to get a jump start on that, to lay a foundation for how these disputes between competing tribunals are going to be resolved, and who can take final jurisdiction over any of the subject matter that conflicts as between them. Unfortunately, the Supreme Court of Canada chose not to do that, which means that this is an unanswered question that's going to raise a lot more conflicts and going to create a lot of a backlog in the judicial review arena. It also means that eventually the Supreme Court of Canada is going to have to set the record straight. Mr. Gilmore couldn't get them to do it, but it's going to happen eventually. And so while this competing tribunals administrative law issue may seem dry on its face, underneath it's actually really interesting because it's a new and exciting area of law. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation, and this video is brought to you by Brazen Bull Creative.